However, they allowed the appellants, that is 272 workmen and employees, to file their individual claims before the liquidator, who, after going through the record and taking into consideration the pleadings, will determine the claim. So this was what was given by the Honorable NCLAT. The appellate tribunal also further observed that if claim of one or the other workman or employee is rejected, it will be open to them. May I request the organizers to kindly mute the people who are not, or maybe mute everyone, and then I will unmute myself.
Okay, ma'am.
Fine. So I hope I'm audible. Yeah. So the appellate.
Yes, ma'am, you're audible.
All right. Thank you. The appellate tribunal also observed that so far as the gratuity and provident funds are concerned, the same cannot be treated to be the assets of the corporate debtor, and they are to be dispersed amongst the employees and workmen who are entitled for the same. So these were the two things which were decided by the appellate tribunal. Now, also giving them the priority that in case any claim is rejected, it is open to them to move before the honorable bench, which may decide the same in accordance with the law. Feeling further aggrieved and dissatisfied with the impugned order, which was passed by the appellate tribunal, the appellants, which comprised of the workmen and employees of the Dahej Yard and Mumbai head office, preferred this appeal to the Honorable Supreme Court. Now, while Ms. Shobha Ramamurthy, who was the learned advocate appearing on behalf of the appellants, submitted on various grounds that why this should be payments should be made to the workmen and employees, that is 272 who were employed at Dahej Yard and Mumbai head office. This is how the facts and the arguments which were presented by the advocate for the appellants go. The CIRP period commenced from 1st of August 2017 and ended on 25th of April 2019, which was the commencement of the liquidation. And that for this entire period of 20 months and 25 days, the employees and the workmen were on the payrolls of the corporate debtor. The RP did not terminate the employment contracts or retrench or lay off the workmen. RP further issued instructions dated 4th September 2017 to all the employees and workmen to report to him and follow his instructions. Further, RP issued an email to HR department of the corporate debtor instructing not to relieve or permit resignation without written approval. So this was how the facts were presented by advocate Shobha Ramamurthy, and the corporate debtor was managed as a going concern in accordance with section 21 of the IBC code. That even the proposal to suspend operations at Dahej Yard and provide workmen with paid leave was rejected by the COC for lack of majority. Therefore, when the corporate debtor was managed as a going concern, which as such is mandatory under section 19 of the IB code, and when the operations at Dahej Yard were not suspended, the workmen employees at Dahej Yard are entitled to at least the wages and salaries during the CIRP period. This is the argument put forward by the advocate of the appellants. Further, she argued that irrespective of whether the wages and salaries for the period during CIRP to be qualified as CIRP cost or not, the Provident Fund, Gratuity and Pension Fund are to be paid to the workmen and employees at Dahej Yard under section 36(4) of the IB code in priority over the other dues, which are also not paid till date. She further argued that throughout the CIRP period, the employees and the workmen of Dahej Yard were asked to assemble at ABG Enclave and sign the attendance register since transportation to the yard was discontinued by the RP. Further, she argued that throughout the CIRP period, the employees of Mumbai office had regularly attended the office, recorded their attendance with the attendance reader installed at the Mumbai office. Further, she has also relied upon the documents from the paper book as well as rejoinder affidavit, which was a proof of the work done by the respective employees and workmen during the CIRP period. Further, she claimed that all the claims filed by the employees and workmen in Form E with the liquidator have been verified. and the verified and admitted claims of the employees and workmen of the corporate debtor for CIRP period on the basis of the records available, including the attendance register, have been uploaded by the RP and the liquidator on 24th of December 2020 on the official website of the corporate debtor as per regulations. Therefore, further verification was not required. Then came the advocate of the RP oblique the liquidator, and the counsel appearing on behalf of the appellants. He further gave these arguments that the counsel appearing on behalf of the appellants has argued and based on the relevant provisions of the IB code in support of her submission that the employees or workmen of the Dahej, Yad and Mumbai head office are at least entitled to wages and salaries during the period of CIRP, and also entitled to the amount due and payable towards Provident Fund, gratuity, and pension. Now, the sections on which he has relied include Section 336, Section 513 of the IB Code, 514. We will come to a discussion of all these: Section 17, Section 18, 19, 20, 25, 33.7, 36.4, and Section 53 of the IB Code. We will just have a brief discussion on each of these and how it is relevant for this case. Further, he argued that the objective of the IB code is for maximizing the value of the assets of the corporate debtors so that they are efficiently run as a going concern. He has further placed his reliance on the decision of this court in the case of Swiss Ribbons Private Limited versus Union of India, and in the case of Gujarat Urja Vikas Nigam Limited. Further, he has argued that under Section 21 of the IB Code, the RP is mandated to manage the operations of the corporate debtor as a going concern, and that for this purpose, he is vested with the authority to issue instructions to the personnel of the CD as may be necessary for keeping the corporate debtor as a going concern. Further, that the RP is under the mandate to take all such actions as are necessary to keep the corporate debtor as a going concern. So the battle now is between the workmen and employees who are claiming the salaries for the CIRP period and the prior period, and the RP and the liquidator, who is the liquidator now, that stating that this salary would not be included as part of Section 53(1)A, but will be included in Section 53(1)B and C. We will come to a discussion on that. He further argued that Section 513 of the IB Code defines insolvency resolution process cost. And as per Section 513 of the Code, the insolvency resolution process cost means any costs incurred by the RP in running the business of the CD as a going concern, and any other costs as may be specified by the IBBI. And in this particular case, the liquidator had clearly provided the costs on account of employees and workmen under the head other services in a running business in forms 1, 2, and 3 submitted by the RP with respect to the CIRP costs incurred by him, that is to the IBBI. That is how the liquidator had submitted the details of the costs. And therefore, the salaries and wages and the dues payable to the employees and workmen during the CIRP period will be qualified as CIRP costs under Section 513 of the IB Code and are liable to be disbursed even prior to the amount distributed under Section 53 of the IB Code. Now, Section 513 clearly states what is comprising of the insolvency resolution process cost, and whatever is comprising of the insolvency resolution process cost should be paid as per Section 53(1)A, which is just saying that the liquidation cost and CIRP cost to be paid in full prior to any further distribution. So this is how the cost, which is supposed to be the CIRP cost. So if the workers and employees payments are forming part of the CIRP cost, then they have to be paid in full. Otherwise, they will have to be paid as per Section 53(1)B and C. So this is how this whole discussion is about how this decision was taken by Honorable Supreme Court as to whether these will comprise of the CIRP cost or not, and whether they will be paid as per Section 53(1)A or 53(1)B and C. Further, he also said that otherwise the Provident Fund, gratuity and pension fund, which remain outside the liquidation estate as per Section 36(4) of the IB Code. So the Provident Fund, Gratuity Fund amount would arise as soon as the employees and workmen are deemed to have been discharged under section 33(7) of the IB code. Now these Provident Fund, Gratuity Fund as per section 36(4) will not form part of the liquidation estate. Therefore, the workmen and the employees have a right over that fund, and that it should be distributed to them once the order of discharge along with the liquidation order is passed under section 33(7) of the IB code. Further, even the workmen and employees are required to be paid the wages and salaries for the pre-CIRP period as per the priorities mentioned in the section 53 of the IB code. Further, he submitted that the council appearing on behalf of the appellants, it was further submitted by the council appearing on behalf of the appellants that the salaries and wages payable to the workmen and employees for the CIRP period are a component of the RP costs, and therefore the CIRP period salaries and wages payable to the respective workmen are to be paid first and not pari passu in terms of section 53(1)(b) and C. Now the whole discussion is about whether they will form part of section 53(1)(a) or they will form part of section 53(1)(b) and C. Because if they are falling in section 53(1)(a), which is the insolvency process cost, then they have to be paid in full. Whereas in case they are forming part of section 53(1)(b) and C, then they will be paid pari passu. So this is how the further discussion goes, that even the workman's dues is explained in explanation 2 to section 53 of the code as the term having the same meaning and as assigned to it in section 326 of the Companies Act. And section 327 of the Companies Act provides for preferential payments upon winding up of a company. It enlists the components of the wages or salaries and dues payable to an employee under clauses B, C, E, and F under subclause 1. Therefore, on a combined reading of the provisions of section 326 and 327 of the Companies Act, it is clear that the workmen's dues and employees
IPA-002, IPN 3023 4023.
It is, please mute yourselves. I request you to please mute yourselves. It is clear that the workmen's dues and employees' dues are comprised of several components, including wages or salary, holiday remuneration, sums due from the Provident Fund, pension fund, and gratuity fund, amongst other items. So as observed by this court in the case of Swiss Ribbons, the costs and expenses of the RP and liquidator are to be given preferential treatment by accepting them from the pari passu principle. So she further argued that rupees 2.75 crores are earmarked and kept apart towards the dues of the workmen and employees. Therefore, the sum of rupees 2.75 crores, which is deposited for the benefit of the workmen and employees, is liable to be disbursed in terms of section 53(1)(a), read with section 513(c) of the IB code. And further, she said that the amount and sum of rupees 16.8 crores, which was approximately payable towards the Provident Fund, gratuity, and pension, in terms of section 36(4) to all the employees and workmen of the corporate debtor, including the appellants, and therefore is required to pay in priority over the disbursement to be made under section 53(1)(b) and C. Making the above submissions and relying upon the aforesaid decisions, she had requested to allow the present appeal to the Honorable Supreme Court. Further arguments given by the liquidator were as follows. The advocate of the liquidator, Shri Nakul Dewan, he was appearing on behalf of the liquidator, and he submitted that the wages and salaries claimed by the appellants who have done no work during the CIRP period and have not assisted the RP or the liquidator during the CIRP would not fall within the parameters of the CIRP costs within the definition of section 513(c) of the IB code. So this has been actually a landmark judgment which has defined as to whether the workmen and employees who have not worked during the CIRP period will fall as a part of the CIRP cost, or they will fall a part of the distribution under section 53(1)(b) and C. Further, he argued that only 8 employees at the Mumbai location for 8 months during the CIRP and workmen and employees from Surat assisted the RP in providing services during required under the CIRP process. So categorically, the liquidator has given how many employees and workmen from Surat and Mumbai have actually helped him and assisted him in providing services for the CIRP process. That the remaining employees and workmen, including the appellants herein, were not required to and did not perform any services to run the corporate debtor during the CIRP. Further, he argued that therefore the COC of the corporate debtor rightly did not approve any payments to the appellants as part of the CIRP costs, as they had not contributed towards the CIRP process. Further, he argued that the wages and salaries of the appellants, workmen, employees of the corporate debtor would fall under section 53(1)(b) and (c) of the IB code, which will be pari passu and not paid in full. Further, he said that in the meetings of the COC held periodically, right from first meeting to the fourth meeting, it was specifically recorded that the Dahej shipyard is not operational and that the corporate debtor is not in a position to pay the salaries of the workmen and employees due to paucity of funds, since the corporate debtor was not a going concern and did not have a running business. So this has been minutized. So it is there from the first meeting to the fourth meeting that the corporate debtor is not being kept as a going concern, especially at the Dahej shipyard, and it is not operational. Further, that the main business of the corporate debtor was shipbuilding and ship repairing, which was carried out at its yards at Surat and Dahej. That the yard at Dahej was not in operation since 2015 and the yard at Surat was closed in October 2017. And therefore, it cannot be said that the corporate debtor was a going concern during the CIRP, and therefore all its employees would be required to be treated as those who assisted the RP to run the corporate debtor as a going concern. So I'm sure all of us who are doing cases must be coming across these questions while dealing with the claims of the workmen and employees as to what will form part of the CIRP cost and what will form part of the distribution as per section 53(1)(b) and (c). So this judgment, this landmark judgment of Honorable Supreme Court definitely puts the matter at rest. Further, he claimed that as such, there is no evidence to suggest that the respective workmen or employees deployed at the Dahej yard and Mumbai head office have actually worked during the CIRP period. And the appellate tribunal has rightly observed that the respective workmen and employees can at least have to prove their claims. So the final verdict by the appellate tribunal has been that the workmen and employees can file their claims to the liquidator, and then he can further check the respective claims and adjudicate upon those claims or verify the said claims. Therefore, the appellate tribunal has rightly not interfered with the order passed by the adjudicating authority in not passing any order in favor of the workmen and employees. Section 53 of the IB code sets out the waterfall mechanism in terms of which the dues of the creditors are paid. Further, he has argued that even the operational creditors fall sixth in line after payment of CIRP dues and the dues of the secured creditors. That even after the corporate debtor goes into liquidation, in terms of section 33 of the IB code, the dues of the employees and the workmen being operational creditors would be paid in last in terms of the waterfall mechanism of section 53(1)(f) of the IB code. This is another argument put forward by the advocate of the RP. It is therefore submitted that the respective appellants, workmen, employees are not entitled to any wages or salaries for the period during the CIRP as CIRP costs as claimed by them. So these are the arguments put forward. Further, the advocate appearing on behalf of the liquidator submitted that the costs incurred during the CIRP period by the corporate debtor and the RP will qualify as CIRP costs only with respects to costs incurred by the RP towards running the company as a going concern under section 513C of the IB code, and in a case where the same has been approved by the COC under regulation 31 and 33 of the CIRP regulations. So only the CIRP costs to the extent ratified by the COC are what will form part of the CIRP costs and will form part of the distribution under section 53(1)(a). Further, he argued that in the present case, the corporate debtor is neither a going concern nor the RP has incurred any costs. Therefore, the wages and salaries of the workmen employees at Dahej yard cannot be included in the CIRP costs. Further, after the commencement of the CIRP, workmen and employees' dues which are outstanding as on the date of CIRP are treated as operational in terms of section 520 and 521 of the IB code. Section 30, subsection 2B of the IB code, as per this, the amount payable to the operational creditors by a prospective resolution applicant shall not be less than the amount to be paid to such creditors in the event of a liquidation of the CD under section 53, or the amount that would have been paid to such creditors if the amount to be distributed under the resolution plan had been distributed in accordance with the order of priority in subsection 1 of section 53, whichever is higher. So he is putting forward his arguments as to why they cannot be paid in full. Further, it was submitted by him that it is only a few of the Surat employees and 8 Mumbai employees who have rendered services during the CIRP period to assist the RP to complete the CIRP process, whose dues would be treated as CIRP costs. So this is the same thing like we've already discussed, 53(1)A and 50 versus 53(1)B and C. Further, he has further brought about, which we have already discussed, that the workmen at Dahej and employees at Mumbai office did not help to maintain the corporate debtor as a going concern. Since number 1, the corporate debtor was never a going concern, and number 2, the Dahej yard was not in operation since June 15. And number 3, the operations at Surat shipyard were completely shut from October 2017. Therefore, the appellants who are workmen of the Dahej yard and 17 employees of the Mumbai head office cannot claim any amounts towards wages or salaries for the CIRP period, since no work was rendered by them, except a few critical Mumbai employees, which was ratified by the COC during the first COC meeting. So it was also dependent upon whether it was ratified by the COC or not. So making the above submissions, the advocate of the liquidator submitted that the wages and salaries of the workmen and employees at Dahej yard and employees at the Mumbai head office, except those who worked during CIRP period, cannot be included or considered as CIRP costs, and therefore they have to be paid as per the waterfall mechanism in section 53(1)B and C of the IB code. So after this whole discussion, the respective workmen employed at the Dahej yard and employees at Mumbai head office were required to submit their individual claims, and which had to be established before the RP and the liquidator that in fact they actually worked during the CIRP period. The appellate tribunal has observed that the respective workmen and employees have to submit their claims before the RP and liquidator, who will further give a verification as to whether, number 1, it was a going concern or not, or number 2, whether during the CIRP period, these workmen and employees have actually worked or not. Now, the judgment by the Honorable Supreme Court was delivered, and how it went, we will just have a brief discussion on that. So we have heard the learned counsel for respective parties at length. This is as per the judgment. And the issue before this court is with respect to the wages and salaries of the workmen and employees during the CIRP period, and the amount due and payable to the respective workmen and employees towards pension fund, gratuity fund, and provident fund. While considering the aforesaid claims, the legislative history and the relevant provisions of the IB code are to be referred to. So considering the relevant provisions of the IB code, excuse me. Section 336, which gives workmen shall have the same meaning as assigned to it in clause S of section 2 of the Industrial Disputes Act. Section 513, what are the relevant provisions which we are going to consider while the Honorable, which were actually considered by Honorable Supreme Court while giving the judgment on this, comprise of these particular sections. Section 513, which defines the insolvency resolution process costs, which mean any amount of interim finance, fees payable to any person acting as a resolution professional. The C part is important. Any costs incurred by the resolution professional in running the business of the corporate debtor as a going concern. So we will discuss the aspects of these provisions which are applicable to this particular case. Section 514, which further says that the insolvency resolution process period means the period of 180 days, beginning from the insolvency commencement date and ending on 180th day. Further, Section 17, which says that the management of the affairs of the CD by IRP from the date of the appointment of the IRP, that the management of the affairs of the CD shall vest in the IRP, and the powers of the board of directors of the partners shall stand suspended and be exercised by the IRP. And the officers and managers of CD shall report to the IRP and provide access to documents and records. And the financial institutions maintaining accounts of the CD shall act on the instructions of the IRP or the RP in relation to such accounts, and would also furnish all information relating to the CD available with them to the IRP. Further, the IRP is vested with the management of the CD, shall act and execute in the name and behalf of the CD all deeds, receipts, and other documents. So this is how the details about how the IRP or the RP would maintain the company as a going concern. Further, the reference has been made to Section 20, which is management of operations of CD as a going concern. That now the important part here is the IRP shall make every endeavor to protect and preserve the value of the property of the corporate debtor and manage the operations of the CD as a going concern. Now, this line is very important, shall make every endeavor to protect and preserve the value of the property of the CD. Further, towards this effect, he can appoint accountants or legal professionals or enter into contracts on behalf of the CD, or to amend or modify the contracts or transactions which were entered before the commencement of the CIRP, or raise interim finance, or issue instructions to personnel, or take any such necessary actions to keep the CD as a going concern. Further reference was made to Section 25, which is the duties of the RP. Further, to preserve and protect the assets of the CD, which is the same as the IRP. And he has to take immediate custody and control of all the assets of the CD, including business records, represent and act on behalf of the CD with third parties. I will just skip this since we all know about these provisions. Raise interim finances, appoint accountants, legal or other professionals, maintaining claims, convene, attend meetings, preparing information memorandum, inviting prospective resolution applicants. So these are all the duties: present all resolution plans at the meetings of the COC, file application for avoidance transactions, further any actions which may be specified by the board. Further reference has been made to Section 33(7). Now, the first part is important. The order for liquidation under this section shall be deemed to be a notice of discharge to all the officers, employees, and workmen of the corporate debtor, except when the business of the CD is continued during the liquidation process by the liquidator. Further, a mention has been made to Section 36(4), which is talking about what is a liquidation estate. The following shall not be included in the liquidation estate assets and shall not be used for recovery in the liquidation. Comprises of assets owned by a third party, which are in possession of the CD, including assets held in trust for any third party, bailment contracts, all sums due to any workman or employee from the Provident Fund, the Pension Fund, and the Gratuity Fund. This is the provision which relates to this instant discussion or this instant judgment by the Honorable Supreme Court, that all sums which are due to any workman or employee from the Provident Fund, Pension Fund, and Gratuity Fund will not form part of the liquidation estate as per Section 36(4). So the rest I will just skip for the time being. I'm sure all are aware of all these details of Section 36(4). Further, Section 53, distribution of assets, notwithstanding anything to the contrary contained in any law enacted by the Parliament or any state legislature. This is how the distribution will be made. Number 1, 53(1)(a), the insolvency resolution process costs and liquidation costs to be paid in full. Further, the following debts which shall rank equally between and among the following. These are the pari passu now. Workmen's dues for the period of 24 months preceding the liquidation commencement date, and the debts owed to a secured creditor in the event such secured creditor has relinquished security in the manner set out in Section 52. And then the wages and any unpaid dues owed to employees other than workmen for a period of 12 months. So these are the provisions which relate to the payment of the wages and salaries of the workmen and employees as per Section 53(1)(a) and B and C. Further, there is F, which brings about the remaining debts which is any remaining debts and dues. This is falling after the payments to be made to the central government and the state government, and also to any secured creditor towards an amount which was unpaid following the enforcement of security interest. So while the Supreme Court delivered the judgment, they have given the legislative history with respect to the employees and workmen's dues towards the wages and salaries, including the amount due and payable towards the Provident Fund, Gratuity, and Pension Fund. So it was promulgated, it was rather proclaimed by in the judgment that any contractual arrangements between the recipients under subsection 1, sorry, this is the continuation of section 53. We will come to the next, how this the legislative history starts. It is under the Companies Act 1956. Section 59A provided that workmen's dues and debts due to secured creditors in terms of Section 529A(1)(c) of the 1956 Act shall be paid in priority to other debts. Further, it provided that in case of the insolvent company, winding up should be undertaken in terms of the laws of insolvency with respect to the status of the persons adjudged insolvent. So this is how the legislative history with regard to the rights and the payments to be made to the workers have been. The provision to Section 59(1) of the 1956 Act provided that all workmen shall deem to have pari passu charge in his favor to the extent of workman's portion. It further stated that where the secured creditor, instead of relinquishing, is enforcing his security, the debt due to the extent of workman's share in the security shall rank pari passu with workman's dues for the purposes of Section 529A. Now, these provisions that we are discussing here, they have been brought about as a part of the judgment delivered by Honorable Supreme Court in this instant case, wherein it is reiterated that how the rights and the dues of the workmen and employees have been protected during various laws which have been followed towards the winding up and liquidation of the companies. So, and how it has been protected throughout the legislative history. Further, it is said that the section was brought in way of the Companies Amendment Bill 1985 with the objective to introduce necessary legislation for the legitimate dues of workers ranking pari passu with the secured creditors in the event of the closure of the company. The objective was that in the unfortunate event of liquidation, the workers who have contributed towards the company and who have been an invisible but perceivable part of the capital of the company, they should not suffer and they should not be deprived of their legitimate right to participate in the product of their labor and effort. So owing to this issue, owing to this the dues of the workers have been duly protected in all acts and in all cases. Section 530 of the 1956 Act provided the waterfall mechanism as per which priority is to be given to different kinds of debts. Subsequently, it was further given for a period of 2 years in case of winding of the company. And then in Section 326 and 327, the overriding preferential payment and preferential payments were introduced, wherein a proviso to Section 326 of 2013 Act was inserted. So here also, as per this Act in 2013, also as per Section 327 and 327, the dues of the workers were protected. However, Section 325 of the 13 was omitted. Then on 15/11/2016, that is when the IBC code was promulgated, Section 325 of the 2013 Act was omitted. On enactment of the IB code, the winding up proceedings in case of insolvency were to be governed by the provisions of the IB code, and the provisions of the IB code only shall be applicable to deal with the winding up proceedings, as the IB code is a complete code in itself. So thereafter, an amendment with effect from 15/11/2016 has been brought in under Section 327(7) of the 2013 Act, wherein it has been clarified that the provisions of Section 326 and 327 of the 2013 Act will not be applicable in the event of liquidation under the IB code. So then it was further that all the decisions would be taken as per the IB code and not as per the Companies Act 2013. This was brought about on 15th of November 2016. Now, in case of any insolvency in a winding up of a company under 326 and section 327, the workmen's dues were also protected, that they shall be in priority to all the other debts. And the workmen's dues for a period of 24 months shall be paid in priority to all the other debts, including debts to secured creditors. This means that the wages and salaries, which were for a period of 24 months, is over and above every other claim, including debts due to the secured creditors. Further, the workmen's dues included the Provident Fund, Pension Fund, and Gratuity Fund, or any other fund for the welfare of the workmen maintained by the company. Under the IB code, the workmen dues have been duly protected, and the Provident Fund, Gratuity, and Pension Fund have also been excluded from the liquidation estate as per section 36(4), like we had just discussed. Now, the Honorable Supreme Court has delivered saying that the issue of giving priority to the workmen dues have been considered time and again in the various committees' reports. In the Bankruptcy Law Reforms Committee, it was agreed that the assets held in by the entity in trust, such as employee pensions, assets held as collateral to certain financial market institutions, and held as part of operational transactions where the entity has right over the asset, but is not the owner of the same, shall be excluded from the liquidation estate. So, the pension fund, etc., were the Provident Fund, Gratuity Fund were excluded from the liquidation estate. It was also debated with respect to the waterfall mechanism, and was agreed that the workmen dues capped up to 3 months will be given the second priority with the secured creditor. So this is as per the BLRC, that is the Bankruptcy Law Reforms Committee report. Subsequently, a report of the Joint Committee on the Insolvency and Bankruptcy Code was prepared and presented in Lok Sabha, wherein the issue of exclusion of Provident Fund, Pension Fund, and Gratuity Fund from the liquidation estate assets was debated. So after the in-depth examination, it was further provided that they will be excluded only. And all these sums, finally it came to a decision that all these sums due to any workman or employee from the Provident Fund, Gratuity Fund, or Pension Fund should not be included in the liquidation estate assets. Thus, to protect the interest of the workmen, the committee decided that the workmen dues for a period of 12 months, as provided under Section 53 of the Code, could be increased to 24 months. So this was how the law was finally promulgated, and after a discussion in the Lok Sabha, it was decided to increase it to 24 months. So the Supreme Court has reiterated how the legislature has worked to actually protect the interests of the workmen and the employees. In the light of the same, the section 36 of the code, it is the outright protection to the workmen. So it has been these share of the workmen's dues comprising of the Provident Fund, Pension Fund, and Gratuity Fund have been consciously taken outside the liquidation process. In light of the above statutory provisions under the IB code and the legislative history, the claims of the workmen and employees towards wages, salaries prior to CIRP and during CIRP are required to be considered. Now we come to the major last question, which is the most important question of this particular case. It cannot be disputed that as per section 513 of the code, the insolvency resolution process costs shall include any costs incurred by the RP in running the business of the CD as a going concern. It is also true that section 20 of the IB code mandates that the IRP or the RP is to manage the operations of the CD as a going concern. And in case during the CIRP, the CD was a going concern, the wages and salaries of such workmen and employees who actually worked shall be included in the CIRP costs. And in case of liquidation of CD, dues towards the wages and salaries who actually worked when the CD was a going concern during the CIRP, being a part of the CIRP costs, are entitled to have first priority, and they have to be paid in full first as per section 53(1)(a) of the IB code. However, while considering the claims of the concerned workmen towards the wages and salaries payable during CIRP, first of all, it has to be established and proved that during CIRP, the CD was a going concern, that is number one. And number two, that the concerned workmen or employees actually worked while the corporate debtor was a going concern during the CIRP. Therefore, the wages and salaries of all the other workmen of the CD during the CIRP who actually have not worked and not performed duties when the CD was a going concern shall not be included in the CIRP costs. So this is the judgment delivered by the Honorable Supreme Court, which is very clearly saying that who have not worked during the CIRP shall not be included automatically in the CIRP costs, only with respect to those workmen and employees who actually worked during CIRP when the CD was a going concern. Their wages and salaries are to be included in the CIRP costs, and they shall have the first priority over all the other dues as per section 53(1)(a) of the IB code. So only the people who have worked will form part of section 53(1)(a) and will be paid in full, as against any other dues towards wages and salaries of the employees or workmen of the CD shall have to be governed by section 53(1)(b) and section 53(1)(c) of the IB code. Any other interpretation would lead to absurd consequences and violate the scheme of section 53 read with section 513 of the IB code. So it has been made absolutely clear by the judgment delivered by the Honorable Supreme Court, which is actually the last word, on IBC, that only the workmen who have worked during CIRP would form part of section 53(1)(a), and the rest would form part of section 53(1)(b) and C. If any other interpretation, more particularly the interpretation canvassed on behalf of the appellants, is accepted, in that case, the wages and salaries of those workmen who had not worked at all during CIRP shall have to be treated or included in CIRP costs, which cannot be the intention of the legislature. On a fair reading of section 513, which defines insolvency resolution process costs, it is observed that the dues towards the wages and salaries of only those workmen or employees who actually work during the CIRP are to be included in the CIRP costs. The rest will be included in 53(1)(b) and C. In the present case, the RP or the liquidator has seriously disputed that during the CIRP, CD was a going concern. It is seriously disputed that the respective appellants, which comprises of the workmen and employees employed at Dahej Yard and Mumbai head office, actually worked during the CIRP. It is true while submitting the claims towards CIRP costs that the RP has not submitted the claims towards the wages and salaries of the appellants. However, still the claims submitted by the appellants will have to be adjudicated upon and considered by the liquidator, and the liquidator has to adjudicate and consider whether CD was a going concern during CIRP. That is number one. Number two, how many workmen and employees actually worked during the CIRP while the CD was a going concern. If on adjudication of the claims made by the respective workmen and employees, it is established and proved that during CIRP, the CD was a going concern and the concerned workmen or employees actually worked during the CIRP, the wages and salaries of such workmen or employees will be included in the CIRP costs as defined under section 513 of the IB code, and they will have to be paid as such as per section 53(1)(a) of the IB code as part of the CIRP costs in full before making any payment as per the priorities mentioned in section 53(1) of the IB code. Insofar as the submission on behalf of the appellants that as per section 20 of the code and as per decisions of the court in case of Swiss Ribbons and Gujarat Urja Vikas Nigam Limited, the RP is under mandate to manage the operations of the CD as a going concern. This is very important. And therefore, it is to be believed that during CIRP, the CD was a going concern. Now, this was an argument put forward by the appellants that as per section 20, the CD has to be maintained as a going concern, and it is assumed that the CD was being maintained as a going concern or operated as a going concern cannot be accepted. This has been delivered by the Honorable Supreme Court. It is true that under section 20 of the IB code, it is the duty of the RP to manage and run the operations of the CD as a going concern. We'll come to the important line which says, however, the words used in section 20 are, the IRP shall make every endeavor to manage the operations of the CD as a going concern. Therefore, even if it is found that the CD was not a going concern during the CIRP, despite the best efforts by the RP, it cannot be presumed that still the CD was a going concern during the CIRP. It depends on the facts of each case. In a given case, the CD may be a going concern, and in a given case, it might not be a going concern. Therefore, submission on behalf of the appellants that as the RP is under mandate to manage the operations of the CD as a going concern under section 20, and therefore it is to be presumed that the RP managed the operations as a going concern, and therefore the workmen and employees are entitled to their wages during CIRP, cannot be accepted. However, the wages and salaries of the employees of the pre-CIRP period will have to be governed as per the priorities mentioned in section 53(1)(b) of the code. Now, so far as the dues of the workmen employees on account of provident fund, gratuity, and pension are concerned, they shall be governed by section 36(4), and section 36(4)(3) of the IB code specifically excludes all sums due to any workman or employee from the provident fund, pension fund, and the gratuity fund from the ambit of the liquidation estate assets. Therefore, section 53(1) of the IB code shall not be applicable to such dues which are to be treated outside the liquidation process and the liquidation assets under the IB code. Thus, section 36(4) of the IB code has clearly given outright protection to the workmen's dues forming part of these funds. Therefore, the concerned workmen or employees shall be entitled to provident fund, gratuity fund, and pension fund from such funds which are specifically kept out of the liquidation estate assets, and as per section 36(4) of the IB code, they are not to be used for recovery in the liquidation. In view of the above, it was finally held that the wages and salaries of the workmen or employees of the CD for the period during the CIRB can be included in the CIRB costs, provided it is established and proved that the IRP or the RP managed the operations of the CD as a going concern, and that the concerned workmen or employees of the CD actually worked during the CIRP. And in such an eventuality, the wages and salaries of those workmen who actually worked during the CIRP period, when the RP managed the operations of the CD as a going concern, shall be treated and paid, treating it as part of CIRP cost, and the same shall be paid in full as per section 53(1)(a) of the IB code. Further, the section 36(4), it has been reiterated that the liquidator shall not have any claim over such funds. As observed herein above, there are disputed questions whether in fact the IRP or RP managed the operations of the CD as a going concern during the CIRP. And there is a serious dispute whether the Dahej yard was operational during the CIRP. There is a serious dispute. And the concerned employees of the Mumbai head office actually worked during the CIRP, and therefore it is directed, this is the final verdict, that let the appellants submit their claims before the liquidator and establish and prove that during CIRP, IRP or the RP managed the operations of the CD as a going concern, and that they actually worked during the CIRP, and the liquidator is directed to adjudicate such claims in accordance with law and on its own merits and on the basis of the evidence which may be laid or produced, irrespective of the fact whether the RP, who himself is now the liquidator, included the claims of the appellants, being wages and salaries during CIRP, as CIRP costs or not. So even if the liquidator earlier had put it as wages or salaries, it should now be decided by laying this formula that number one, it is a going concern or not. Number two, whether the particular workmen or employees have been working during the CIRP period or not. The liquidator is directed to adjudicate such claims independently. If it is found that they managed as a going concern, this is the same thing. Then it will be as per section 53(1)(a) of the IB code in full. Otherwise, they will be as per section 53(1)(b) and C. Further, in this particular case, he was directed the aforesaid exercise shall be completed within a period of 12 weeks from today, and such amount shall be paid out of the amount which is directed to be kept aside earlier by the adjudicating authority and thereafter by this court. So this was the liquidator is directed to keep aside the said amount exclusively to be used for workmen dues, which is to be paid on adjudication as above. So this is the final verdict which came out of the Supreme Court, Honorable Supreme Court, on this particular issue of the workers in the instant case of ABG Shipyard. If anyone has any questions, I would welcome.
The participants may ask questions if they have any.
I hope the concept and the whole judgment delivered by the Honorable Supreme Court is clear to all the members, all the participants. In case anyone has any questions or observations, I would request you to please share. Okay, I think there are no questions.
Yes, ma'am.
So I thank
So-
you. I thank you all for being there. Thank you very much. Yeah.
So thank you so much, ma'am, for the session. I hope all the participants got the insight of this particular case, and I hope the session was useful for all the participants. Thank you so much, ma'am, for your time.
Thank you. Thank you very much.
Thank you, madam. Thank you.
Thank you.
Thank you so much. Thank you so much.
So for the second Supreme Court case, we have Mr. Ashok Juneja sir with us. Um, He will take the case on Consolidated Construction Consortium Limited versus Hydro Energy Solutions Private Limited. And Mr. Ashok Juneja is a advocate, insolvency professional, and a valuer. He is also director of Mantra Insolvency Professionals Private Limited, which is an IPE. He has handled many cases as IRP, RP liquidator, and he is a law graduate, company secretary, cost accountant, MCOM, and has an overall combined experience of more than 45 years in corporate laws, including appearances in Supreme Court, High Courts, NCLT, NCLATs, and DRTs. So we welcome you, Juneja sir, and now you may address the participants.
Thank you very much. Good evening, everybody. So this session is for 1 hour and it is on the Supreme Court case, the Consolidated Constructions Private Limited versus Hydro Energy Solutions Private Limited. While delivering this lecture, in between, if you have any question, please ask, no problem. And moreover, last 10 minutes, I will especially devote for question and answers. And at that time also, you can ask your questions. But in between also, if you have any problem, you may please ask. Okay, let's start. Is it visible? Deepika ji, is it visible? Presentation?
Yes, sir, it is visible.
Go ahead.
Yes, sir, you may.
Yes.
Yes, sir. Yes.
Thank you. Thank you. Okay. Now, this is a Supreme Court case. Civil appeal number was 2839 of 2020. And the title of the case is Consolidated Constructions Consortium Limited Appellant versus Hydro Energy Solutions Private Limited. For the facilitation of the participants, instead of appellant, respondent, because these are more or less legal terms which we speak in the court during the arguments, I will stick to more the word like consolidated and Hydro, CD and operational characters, which normally we as a IP understand much better. So this is divided into various sections. This judgment is of around 28 pages. The judgment came in February 2022, and it has been divided into the appeal. Then factual background. Appeal means basic background. Then factual background. Then submission of counsels. Then whether the applicant is an operational creditor, statutory provisions, judicial precedents, and then the analysis and evidentiality value of the respondent's MOA, and whether the application under Section 9 is barred by limitation, and conclusion. So I will try to make it as interactive as it can be. So now the question is, first question is that this appeal was what for? You know, the basic appeal was that in December 2018, the NCLT Chennai bench admitted a application which was filed by the appellant, that is the consolidated. It was filed by them, OC also, against the Hydro Energies. So when it was filed, the Honorable NCLT Chennai admitted the application, and the CRP process was commenced. The CRP process was commenced. Then thereafter, the Hydro went for the appeal in NCLAT, that means NCLAT, in December 2009. Though this was in NCLT Chennai, and now since 2021, there is a NCLAT at Chennai also. But prior to that, in 2019, the Delhi NCLAT was handling this case, this appeal. And Mr. Mukhopadhyay was the chairperson. Most of them you'll be knowing at that time, Mr. Mukhopadhyay was the chairperson of NCLAT. So the NCLAT, the Honorable NCLAT, reversed this decision with the remarks that is not an operational creditor, and then limitation, MOA. So these questions were there. This was decided in December 2019. That means a year after this, when the NCLT commenced. So then he said that the judgment was that the CD was released from the rigors of CIRP, and the management was handed over to them. So after 1 year almost, the CRP was terminated. Then the consolidated, that OC, went for another appeal. They went for appeal to the Supreme Court. You know that under 61, the appeal is to the NCLAT, and under 62, Section 62 of the IBC, the appeal is to the Supreme Court. They went to the Supreme Court, and Supreme Court, by its order in November 2018, 2019, stayed the proceedings of this order. That means again the CRP was recommenced, and thereafter by 4th February 2022 they disposed the matter. So
You are muted. You're not audible.
hello, am I audible now?
Yes, you're audible.
So by that interim order, the Honorable Supreme Court stayed the operations and stayed the impugned order of Honorable NCLAT, and therefore the CRP again recommenced. And thereafter, by the February order, they disposed of 2022. They disposed of the appeal. This is the basic background of this appeal. Then factual background. Factual background is what are the facts of this case. Now, what happened in this case? Mainly, there are three parties which were involved in this. One was the OC itself. Now, OC was the supplier of metro of Chennai. So the Chennai Metro Rail Limited, they placed an order with the OC, that means with the consolidated, to supply them some energy lights. Now, since that at that time the CD, that means it over the sole proprietorship. So they placed the order to the proprietary concern, and they also made an advance of 50 lakhs. In fact, this advance of 50 lakhs was made by the Chennai Metro directly to the sole proprietor, that means Hydro. That means, in other words, this money was not paid by the OC by the operational creditor himself. So there were 3 purchase order, and then a 50 lakhs was also advance paid by them. And this was of 2013, 24th June 2013. Then what happened? Then while issuing the check, the Chennai Metro specifically provided that whatever the schedule is, they had to adhere to the schedule, and only then this contract further will be valid. Otherwise, they will have to refund the money. But when in between, in 2014, on January 2014, the Chennai Metro cancelled their order. They said they don't want to go ahead with this project, and they asked him to refund the amount. Otherwise, they said that they will debit it in near future to the OC that will consolidate it. Consolidated said that stated to the informed to the CD that since that matter this has been cancelled, and therefore you please refund this money. But in the meantime, sole proprietor they encashed the check, and they said that since this matter is, though this is not very relevant, they said no, they have not received the intimation from the OC on 2nd January 2014. That means consolidated. They said they claimed that they have not received the intimation. But this point is not very relevant, that whether they received on that day or not. In fact, the relevance is much later. And therefore, they have deposited the check of the Chennai Metro, the OC, that means consolidated, said that you return the payment to us. Because why? Because what Chennai Metro did, that they told the OC that if you don't return this check, we will adjust it from the dues in future. And they said, no, you take the money from us at this moment itself. So they paid the money probably to maintain good relations with Chennai Metro. So they said, since we already returned to them, therefore you to the CD, they said, since we already returned the money to Chennai Metro, you refund this amount to us. Earlier, in the earlier stage, they said, no, we cannot return to you since the check was from Chennai Metro. You had to give us a letter from the Chennai Metro that this amount, they will not claim in future about this claim. Okay. Then there was a meeting also, a joint meeting also held in that, wherein they said we are agreeable to return the amount, provided you receive a letter from them or you give us a bank guarantee. This OC told them that we are ready to give you an indemnity bond, indemnity letter, that in case tomorrow any liability arises because of that, once you pay to us, that will be our problem, not your problem. Though they said CD said, no, we are not agreeable for that. You give us either a bank guarantee against that. But then again, against the bank guarantee, they refused, OC refused to give any bank guarantee. And then they said, okay, you get a letter from the Chennai Metro that if any tomorrow, if any claim comes, the Metro Rail will not have any, Chennai Metro will not have any claim from us. You get a letter from they said, okay, agreed. So then Chennai Rail itself give them a letter saying that this is on 13 para, if you see, with reference to your letter and a reference above, it is confirmed that CMRL means Chennai Metro Rail Limited have issued a check of 50 lakhs, billing number this and this, based on the request of Messrs Consolidated, that means OC, to Hydro Energy, that is CD, as a part of the special advance to CCL under this, and by contracts duly debiting CCSL account. But then again later on they said, this Chennai Metro has not mentioned clearly that once we pay, we will not have any further future liability of yours. Still, they did not pay that money. So what happened? Thereafter, they send this consolidated one. That means the OC again send a letter to the proprietary concern. That means this stating that the amount of 50 lakhs along with interest you pay us at the rate of 18% on or before 4th March 2017. In reply, the proprietary concern refused and noted that they are only aware of the termination of the contract. They were not earlier aware, and we came to know only on 23rd July 2016. Though the Supreme Court later on also had that this date is not relevant. The only 23rd July 2016 is relevant. The further the lighting fittings, they stated that they're in godown, their warehouse, they are running all the material which was to be supplied, and therefore there is a loss of that. There will be a loss due to that also, and therefore they are not agreeable to refund that amount of rupees 50 lakhs. Then on 18th July 2017, all you are aware that under Section 8, a demand notice has to be served to the CD in case the OC claims any amount from them, and that has to be in form number 3 and 4. 3 or 4. 3 is regarding the demand notices, and 4 says regarding the invoices, and the rule says or. So that means either in form number 3 or 4. Though in practically as a whenever there is invoices involved, as a practically we have the practice of sending both form 3 as well as form 4. So, but that is optional whether you send form 3 or form 4. And say that, and in the demand note they claimed an amount of 83 lakhs 13,093.73. That means 50 lakhs the principal amount, and rest 43 lakh 13,000 the interest thereon. Then on when they filed the application under Section 9, which is relevant for the operational creditors, and you know that has to be filed in form 5. For FCs it is form 1, and for operational creditors it is form 5, and they filed the application under 5.5. And while during the hearing, the Chennai bench admitted the application on this plea that the though it was earlier it was a sole proprietorship, but through a mentioning in the object class under class 4 of the memorandum association, the company, this company, True Energies Private Limited, has taken over that sole proprietorship, and therefore that stands to now in the name of this corporate company. So, and then the counsel for the corporate debtors said the proprietorship is paying the income tax and all those things, but eventually they said no, it has been since 50 lakhs you have received it, therefore you are a corporate debtor and you have to pay to the OC, that means consolidated, and therefore they passed the order in favor of consolidated. That means, in other words, they admitted the application and the CRP was commenced. Then the CD, that means Hitro, appealed before the Honorable NCLAT, and they are by the order of 12 December 2019, that means after almost after a year, the order of NCLT, Honorable NCLT, was set aside by the NCLAT, and they said that if you say, however, there is nothing on the record to suggest that any list prepared Messrs. Hitro Energy Solutions Private Limited has taken over by Messrs. Hitro Energy Solutions. So what they said, that though they have taken over, but there is no list provided therein that what type of liabilities taken over and what type of assets they have taken over. But in any case, they have taken over, but since there is no list specifying that which assets and this liability has been taken over, therefore we cannot say that this validates the liability of the sole proprietorship also. Now then they further said that the purchase orders, which makes it clear that consolidated, that means OC, does not come under the meaning of the operational creditor, because they have not supplied any goods nor given any services to Hitro. The point was, for the operational creditor under Section 520 and 521 operational debt and operational creditor, whether the goods are to be supplied by the operational creditor. They said in this case, consolidated, who is claiming as an operational creditor, neither they have supplied the goods, nor they have provided any services. Therefore, under IBC, they cannot be termed as operational creditor. And since they are not operational creditor, therefore they cannot come under section 7 or 9, whatever it may be, under the IBC code. This was the main two pleas taken by the Honorable NCLAT while rejecting the impugned order of Honorable NCLT. Then submission of counsel. Now, when the matter came to the, then again OC consolidated claim filed an appeal under section 62 of the IBC with the Honorable Supreme Court. And when the matter came up before the Supreme Court, now what was the submission of counsel for the appellant, that means for the OCC? The counsel of the consolidated said that Mr. MP Pratibha, that the MO of the respondent, that means respondent means CD, the memorandum of association states that one of its 4 objects to take of the proprietary concern. Thus, the finding contains in paragraph 7 of the NCLAT judgment that there is not list nothing that respondent has taken over the respondent concern is incorrect. His plea was that once all the assets and liabilities of the sole proprietorship has been taken through the object class of the newly incorporated company, there is no question that the complete list was provided to given, whatever the assets and liabilities was as on balance sheet in the sole proprietorship, those are deemed to be have been taken over by that company which is incorporated. Therefore, the list is the mentioning of the list is not relevant at all. It was not required to be listed. Then they said, he said that it is very clear that the payment of 50 lakhs was made by the OC, that means by the consolidated, to the Chennai Metro Rail Limited, and thus it becomes due from the respondent to the applicant, since they have paid to them, and therefore it is due from that, due from the CD. Again, the application is an operational creditor. He says, while the framework IBC, since the purchase order for light things were in relation to the operational requirements of the appellant. His point was that as a OC, though we have issued the purchase order, and this comes within the frame of IBC, as the light fittings as goods were to be as per the operational requirement of the OC, because it's the OC who has given the purchase order to the CD, though the payment was made by the Chennai Metro directly. But there was no preview of contract between the Chennai Metro and the CD. The preview of contract was between the operational creditor and the CD. I hope you all are clear about the term CD and operational creditor. So then the application under section 9 of the IBC is barred by limitation. This was another key. He said it is not barred by limitation. The opponent has said that it is barred by the limitation. No, he said it is not barred by limitation. And then on behalf of the respondent, that means on behalf of the CD, the counsel, Mr. K. Parameshwar, his arguments were that since the appellant, that means consolidated OC, has been dealing with the proprietary concern only, and not with this company corporate debtor. Therefore, though the respondent's MOA has stated that the intention to take over the proprietary concern, the respondent, that means the CD, changed his intention through a subsequent board resolution. Very important point they brought in. Though the MOA stated that the sole proprietorships will be taken over by this corporate debtor which was incorporated, but he says later on the board resolution, it was decided by them that we will not take this proprietary concern, and therefore the liabilities of proprietary concern, in any case, the liabilities of not the corporate debtor, and therefore they cannot file an application under Section 9 because Part 2, Section 9 only deals with the corporate debtors, not with the individuals, proprietorships or partnership firms. So therefore, they said that it cannot be under Section 9. They cannot file an application since it's the sole proprietor who is liable to pay them. And then they said there is no privity of contract between the OC, that means, and the respondent, that means CD. Since the appellant contracts was with the proprietary concern, because जो proprietary concern थी उसके साथ उनका कॉन्ट्रैक्ट हुआ था, and there is no preview of contract with the corporate debtor, क्योंकि उन्होंने मना कर दिया कि हम इसको liabilities को नहीं टेक ओवर करेंगे. Then जो payment of advance, then the payment of advance was made by the proprietary concerns were by the Chennai Metro, and therefore the appellant, that means this OC consolidated, is not the operational creditor, because the operational creditor did not provide any goods or services to the respondent. Very important point they brought in, but then Honorable Supreme Court dealt it with in detail later on. The appellant, the appellant means the OC did not provide any goods or services to the respondent because they have only purchased, given the purchase order for, and the supply was to be made by the CD. Only over the goods and services from the proprietary concern. Hence, they said, the opponent counsel said that it will not come under the definition of operational creditor under Section 5, Section 20. Then even if it is a debt that is in the hand of Chennai Mail and which has not legally transferred it to the OC. So he said, even if the payment their due is that to the Chennai Metro and not to the OC. And they said the application is barred by limitation since it was filed on 1st November 2017. That is more than 3 years of default on the 7 November 2013. You know, under Article 137 of the Limitation Act, it has to be filed within 3 years. And they claim that since it was filed on 1st November, which was more than 3 years of the default. So this question is also very important. The appellant is seeking to misuse the present proceeding under the IBC for recovering his dues. He said, in fact, during this arguments, that this IBC is not for a recovery procedures. It is not for a recovery court, and therefore they cannot go for recovery. It is for resolution only. And the last were that therefore no dues are to be paid by the CD to the OC. Now the rival submission will now be considered. Number one, question is number one, very issue, that is means issues involved, whether OC, appellant, that means OC is a operational creditor or not. This is question number one. Now the primary submission, now this is what now Supreme Court, Honorable Supreme Court starting its deliberations and its observations. They said the primary submission of the respondent, that means CD, which was accepted by the NCLAT, is that the consolidated one is not the OC and is not therefore not an operational creditor within the ambit of IBC, and therefore its application under Section 9 of the IBC was not maintainable. So what the Honorable NCLAT said in his impugned order, that is not an operational creditor. That the consolidated one is not that this Consolidated Constructions Consortium Limited is not the operational creditor. And now the Supreme Court, Honorable Supreme Court, further ahead with it with the relevant provisions whether this OC is the operational creditor or not. Now now these are the observations of the Honorable Supreme Court. Section 5, Section 20 of the IBC defines operational creditor. What it says? It says operational creditor means a person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. So it says very important definition. means a government to whom an operational debt is owed. That is a operational creditor, or includes any person to whom such debt has been legally assigned or transferred. Now, this is the operational creditor. Now, what is operational debt? That is very important. It says operational debt is under section 5, subsection 21, defines the meaning of the operational debt. Now it says operational debt means a claim, very important, means a claim in respect of the provision of goods or services, including employment, or a debt in respect of the repayment of the dues arising under any law for the time being. That means it says it must be a claim in respect of the provision of goods or services. Two things he says. For us today, important is goods or services, because he's not a worker, he's not an employee, it's not a corporate dues. So let's forget the above. Let's concentrate on this, that they say the operational debt means a claim in respect of the provision of goods or services. So we have to emphasize on the words a claim in respect of the provisions of goods and services. We'll deal it slightly later. So, but this is the important emphasis. Then, as an operational debt needs to involve a claim in respect of the purchase of goods or provisions, the phrase claim is defined under section 3, subsection 6 of IBC. What it says? What claim is? Right to payment, whether or not such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured, unsecured. It says claim is right to payment. There must be a right to payment. And second is right to remedy for breach of contracts under any law for the time being in force, if such breach gives rise to a right to payment, whether or not such right is reduced to judgment. He says there is a right to remedy for breach of contract. If there was a payment was due, claim was there, and if there is a right or legal remedy in case of breach of contract in that under any law, that means there will be a claim. So these two essential ingredients are required for a claim. So, just a moment. Claimants. Then now section 8 of the IBC, which explains the steps that the operational creditor needs to undertake prior to filing a claim. That means section, in case of you may be all aware that in case of financial creditors under section 7, no notice is required to be given. But in case of operational creditor, a legal notice must to be provided under section 8. Now they say under section 8, the operational creditor has to do the following. What first? That he, if there is an occurrence of default, he has to deliver a demand notice of the operational unpaid operational creditor involved in the default. He has to mention about the default and the amount of that. Then the corporate debtor, within a period of 10 days, he has to either, on the receipt of the demand, he has to either say that he has paid the money, or he can give the proof evidence of paying the money, or two, and then in accordance with section 8 subsection 1, the operational creditor send a demand notice to the corporate when a default occurs, to the manner which may be, that is not very important, because he never disputed, the CD never disputed that he has not received the demand notice. He always said that he has received the demand notice. Therefore, whether once he has received the demand notice, so this question does not rise much, that whether it was to be delivered by, but he says that when a default occurs and the manner in which the prescribed default, now default has to be there. I may inform you one thing more, that in case of financial creditor, there are three ingredients which are involved. That means there should be default, there should be financial creditor, and there should be a financial debt. But in case of under section 9, 4 ingredients are required to be there. One, the default is there. Two, the operational creditor is there. Third, the operational debt is there. And the fourth one, there is no dispute. So that dispute element is not required in case of there are various judgment to that. But in case of operational creditors, so these are the 4 ingredients. So it says default has to be there, whether it is financial creditor or it is. So what default is defined? Now, what is the default has been defined? Default has been defined under section 3, subsection 2. And it says default means any non-payment of debt when whole or any part or installment of the amount of the debt has become due and payable and is not repaid by the debtor or corporate debtor as the case may be. That means even if the installment is due, he is not paid, part amount even if he has not paid which was due, there is a default. So after occurrence of the default, he can go further for filing of the claim. But in case of operational creditor, he has to give a prior demand notice. And in case of financial creditor, he need not to give a prior demand notice. He can straight away go to the filing the application under section 7. But in case of operational creditor, he has to give a notice for 10 days at least with a 10 days time to the corporate debtor. And if he is not satisfied after 10 days, then he can go to the honorable NCLT and file a application under section 9. So default is defined, claim is defined, operational creditor is defined, and operational debt is defined. Now it is to be seen whether there is any dispute or not, the fourth element. So 2 options available with under the IBC. Either he highlights a pre-existing dispute. That means if he says that there is a pre-existence of dispute, in that case also the operational creditor application can be rejected. But he has to prove that there was a pre-existing dispute, and pre-existing means at least before getting the demand notice under section 8, there was a dispute. He cannot raise the dispute after getting the demand notice, because then it will be taken as it's a afterthought event. So if there was a dispute, he has to prove the corporate debtor that there was existence of arbitration proceedings or some case going on in the court of law, and therefore there is an existing dispute as well as this due amount is concerned, and in that case also the application of the OC may be rejected by the honorable NCLT. So they said that now 2 options available under section 8(2) of the IBC to highlight a pre-existing dispute or to prove that the debt has already paid. So now rule 5, again not very material in this case, because he says whether the demand notice has been delivered or not, because he has already admitted that the demand notice was delivered to it. Therefore, it is not very important as far as today our session is concerned. So then he says in form number 3 or 4. Now you see if the second line you see, thus under rule 1 or rule 5, an operational creditor can send the demand notice under section 8 subsection 1 of the IBC through 2 methods: a demand notice in form 3 or a copy of the invoice attached with the notice in form 4. Therefore, now what form 3 requires? He requires the following details. Now, as far as notice is concerned, invoices is concerned, under section 8 is concerned, form 4, sometimes if one is employee or workman, there will be no question of any invoice in that case. It may be that to prove he can give appointment letter, but not any invoice. So it is or either in demand 3, form 3 or demand 4. But I told you as in the earlier, as a practice, if it is a supply of goods or otherwise, we give both the forms, form 3 also and form 4 also. Because in the very beginning when the IPC started, this was a question that form 4 has not been received by us. The CD used to contest on this basis. So then we made it a practice to send both the forms. Then Okay. Then so hence a demand notice has to be sent by them, and it was admitted by the CD that it has been received by them. So the above conclusion is supported by the Board of India Insolvency and Procedure for Corporators Regulation. The claim now it says Supreme Court, Honorable Supreme Court further ahead of the claim, because once the claim is filed by any person to the IRP, then the or RP, as the case may be, then the question is what he has to see while accepting that claim. So it says that claim by the operational character. It provides the CRP regulations process provides that a person claiming to be an operational character other than workman or employee of the operational character shall submit proof of claim to the interim to the IRP in person by post or by electronic means in Form B of the schedule. So whenever in Form CRP process, Form A is for publication, Form B is for claim by the operational character, Form C is claim by the financial character, and Form D is for the form by the other than by the workman, and Form E is by the association of the workmen. So Form B is relevant by the operational character where is the supplier of goods or services. So it says that in Form B, the claim has to come to IRP. Now this claim is different what the claim is before the Honorable NCLT. NCLT admits it, and when the publication is there by the IRP to file the claim with its any creditor of the company, whether financial creditor or operational creditor, this comes at that time. That if there is any operational creditor, including the applicant, that means who initiated it, the claim can be by the operational creditor in Form B, and provided that such person may submit supplement documents. This is the existence of client due the operation under this regulation we provided on the basis approved on the basis of the record available with the information utility, if any. The information utility, though provision was there from the very beginning in the IBC 2016, but its implementation was not there. It came later on, but now we have made a practice during the last 2 years that we always file our claim with the NESL to prove that later on that this was a claim. So it says either through the NESL or the other documents are given over there. So the existence of debt due to the operation under this regulation may be provided on the list of records available with the information utility or other relevant documents, including the contracts for the supply of goods, services, invoices, etc., etc. So now even these things are not very important because this has already been not relevant for the decision. Now I go to the relevant point. So he says that after Section 8 is completed, formalities are completed, then you can file the application under Section 9, which is in this case, this section under Section 9, the applications are filed. So what are the ingredients of Section 9? These need not to be explained at this moment because paucity of time and not very relevant for the decision also of the Supreme Court. Then is once this is there, then that it says that it has to be in form number 5, and form number gives the details that what are the particulars which are to be furnished while filing the form number 5, which is relevant for the purpose of claiming operational debt. Now then he says he has given the legislative history, which you must be aware, very important cases by the Supreme Court. He has said that secured creditors and unsecured creditor, again you know very well about this, and again this is not relevant for this judgment as on today. Then he says then Bankruptcy Law Reforms Committee, BLRC, what I said, that he has made the distinction between financial creditor and operational creditor. Again, theory more, practical less at this moment, not much relevant. Then so it says that the operational creditor are those who debt arises from operational transactions. So the Joint Parliament Committee also held the same one, and there was a constitutional decision also by the Honorable Supreme Court that it was held that operational creditor and financial creditor can be differentiated, and their rights and obligations are also different. then we come to the next, that is, let me go to the relevant. Then it says Innovative Industries Limited versus ICICI Bank. Two judge bench explained the phenomenon IBC in relation to the operational character, triggering the CRP. Again, though relevant, this is relevant to that extent only, that is the operational character. For this purpose, they have taken some arguments point from over here. Otherwise, they say that whether the main question was issue involved was whether the operational character is a operational character or not. Because the decision of Mobilex Innovations, very important case. And then again also they said that corporate debt which is in turn could jeopardize the financial debt. Their question was why the only authorities are to the financial character for COC, and why not to OC also? Again, this is not relevant for us, because here the question is not OC or FC. Here the question is whether in this case the operational character is a operational character or not. Now, operational character has been defined in so many decisions. So again, so in various judgments, these Honorable Supreme Court previous judgments try to explain that whether he is an operational character or not. So after that, the analysis was that the basic analysis was why he is an operational character. The Honorable Supreme Court held that he is an operational character. This Honorable Supreme Court giving various definitions, and these judgments ultimately pointed out or stressed that the operational character need not be a supplier of the goods, only supplier of goods. Even if he has paid the advance against the supplier goods, the supplier and goods were CD. He was not the supplier of goods or services. Nowhere in the definition of operational character or operational debt it is mentioned that he must be a supplier of goods or services. It is mentioned that it should in relation to the goods or services. So his claim is in relation to the goods or services. It was to be supplied by the CD, not by him, not by the OC. Doesn't matter. So the definition of the operational character is not restricted to only that he should be a supplier of goods or services. So in the conclusion analysis, he said, no, the Honorable NCLAT was wrong in narrowing this definition only to this, that he must be a supplier of goods or services. And in this case, though he is not the supplier of goods or services, supplier of goods or services was that earlier proprietary concern, and therefore it has been taken over by them, therefore he is the operational character. This was the first issue which was decided by the Supreme Court, Honorable Supreme Court, in favor of the appellant, that means the OC, consolidated one. Again, he has given various, and ultimately he said that COC and all those things not concerned whether that is excluded or included or not, that is a different discussion at all. Then is the second question was MOA. Now the plea of the respondent, that means the CD, was that though initially they agreed, and in the memorandum also they pointed out that the under clause 4 of the memorandum of association association, that under clause 4 they will take over the liabilities and assets of the proprietary concern. But later on, through his board resolution, they disagreed and they said that no, we won't take the liabilities and assets of the sole proprietorship, and therefore they are not liable for that. Now, two things happened over there. One was this plea they have not taken before the Honorable NCLT Chennai. They took it only when before the Honorable NCLAT. They took this plea. Yeah, there was a subsequent board resolution where the company said will not take over the liability assets of the proprietary concern. Now they said the Supreme Court, Honorable Supreme Court observation was, number one, this was impropriety on the part of the residents, on the respondent, that means on the CD, not to disclose this detail Either they have manipulated with the backdate, not to give this detail to the NCLT, and only to give is NCLAT. Number one. Number two, even if it is there, whether that board resolution passed by the board regarding that now they will not take over the assets and liabilities of the sole proprietorship is valid or not. Now, this is dealt with whether they are valid or not. So they say we have to go to the regarding this, whether the memorandum association of dated 24th January 2004, we state that for to take over the proprietary form. Now the point is, if they don't want to take over the assets and liabilities of the proprietorship, in that case they were required to amend the memorandum of association. Now there is a procedure under the Companies Act to amend the memorandum of association, and this says that section 10 subsection 1 defines that number one, there should have been board resolution, there should have been general meeting, it should have been adopted, passed for the change of the object class. Then the object class must have been registered with the ROC, and the ROC should have given their consent, and only thereafter, once the ROC gives his permission, allows to amend the object class, to amend the, only then it is valid. Before that, there is no validity, any validity of the resolution unless it is registered with the ROC. So they said that even if the board resolution was passed, it was not supported by further AGM or EGM, not further supported by any registration with the ROC, not further supported by the ROC registration. Therefore, that board resolution does not stand any validity in the eyes of law, and therefore, even if whether they resort subsequently to take over or not to take over the assets and liabilities, it will be deemed as per clause 4 of the memorandum object class of the memorandum of association. It stands valid as on today also. So therefore, the Supreme Court has held that this memorandum of association stands invalid, any board resolution, and that memorandum of association stands, and therefore the CD is liable to take over the liability of the sole proprietor as mentioned in the object class. So then so admittedly they said now the third question came up, whether it was a limitation, whether it was within the limited period or not. Now the question is, they said the CD has their point. CD point was that since this was in November 2013 and it was filed in 2017, there was also outside the limitation period. Now the Honorable Supreme Court said that the 3-year period is not from the date of check, it are the date of agreement or purchase order. It is from the date of default, when the default was there. So they said it is clear that since the Limitation Act is applicable to the application filed under section 7 and 9 of the code, from the inception of the code, article 137 of the Limitation Act gets affected, the right to sue therefore accrues when a default occurs. If the default has occurred over 3 years prior to the date of filing of the application would be barred under article 37 of the Limitation Act. So they said date of default is very important for that, and not when he has the right to sue, because the right to sue is after date of default. And this is not very convincing that when the order was placed. So he said in the present case, the Chennai Metro issued a check of 50,000 on 7th November 2013. However, at that time it was issued as an advance payment for the purchase of the value. It was only after 2 January 2014 that Chennai Metro terminated its project with the appellant, and it was after that only that the proprietary concern encashed the check. Subsequently, correspondence was exchanged between the appellant and the proprietary concern in July 2016 in relation to the repayment of the amount, Therefore, a joint meeting was held on 4th August 2016. Till the point in time, both the parties were agreeable, negotiable in negotiation in relation to the payment order and balance meeting order, and therefore it shows that the default occurred only after 4th August 2016. And since they have filed the application in 2017, it is perfectly within the limitation period. So the conclusion was, therefore, the conclusion by the Honorable Supreme Court was, number one, the applicant is an operational creditor under the IBC, since an operational debt will be included debt arising from a contract in relation to the supply of goods or services from the corporate debtor. Number two, the respondent will be considered to have taken over the proprietary concern in accordance with the MOA, Memorandum of Association, and the application under Section 9 of the IBC is not barred by limitation. Therefore, the appeal was allowed by setting as the impugned judgment and the order of the Honorable NCLAT dated 12 December 2019. So this decision came on 4th in February 2022. That means after almost 2.5 years. And since there was a stay earlier of this on this impugned order of the NCLAT, the CRP proceeding was going on. Therefore, they said that since the CRP is going on due to this court order dated 18th November 2020, no further actions are required. That means that will carry on. That will carry on. So thank you very much. Any question? Any question from anybody?
I think the participants do not have any questions, sir. So,
Hopefully they are clear what I have said.
yes, sir, they must be. So, shall we end the session, sir?
I kept last 10 minutes for question answers. If there is no question after that.
You can ask any question not related to the case, but general also. If you want to discuss anything related to IBC, you can discuss. You have a platform.
So IBC is very clear to everybody, right?
Maybe we can close the session, sir.
Okay.
I think it's Friday evening and everybody.
So,
Yes, sir. So thank you so much, sir. Thank you so much for the session. And I hope all the participants learned something from sir and from the Supreme Court judgment, and they'll apply this in their future cases. So thank you so much, sir, for sparing your valuable time with us.
thank you. Welcome.
Thank you.
Thank you very much. Thank you, everybody.
Thank you.
Thank you,
Thank you.
Thank you. Thank you.
Thank you, Deepika ma'am.
Thank you. Thank you.
Thank you.
Thank you, everybody.